question. And the second question says, hi, the PLA team. We have signed a lease. We have a signed lease from a tenant, and then the money has been paid. The landlord has not, though, returned a signed accepted lease to us, right? The tenants have decided to take then a different property, also through us. And then we have notified the landlord that the rental is not going ahead. The landlord is now demanding his rental money and threatening then threatening legal action, even though he has not signed the lease. So the question here says that I would like to clarify if the landlord has any right to the money, please. And then to their knowledge, the answer is no, but they would appreciate some professional advice with that regard.
Okay, so basically I'll break the question down into sort of a simple aspect and then a complex aspect. So the simple aspect is just starting with regards to how agreements are formed in law, okay? And obviously specifically South African law. Now, in terms of South African law, each agreement that is formed between people has two elements. There's an offer by one party and an acceptance by another party, okay? And this happens everywhere in all contractual bases. As simple as, you know, you going and grabbing something off the shelf at your local petrol station. There is an offer, there's an acceptance, and that has to be communicated between parties in order for that contract to come into place. All right. And all contracts have this sort of basis, no matter how complex the contract is. So there has to be an offer and an acceptance by the party. Now, when you get into more complex contracts, when you get into contracts that are in writing, okay, parties can dictate how offer and acceptance must be communicated or received by each other, okay? And this is something that we do see in lease agreements. I will say it's more prevalent in commercial contracting than residential contracting, but that doesn't mean that it can't be in residential contract as well, where the parties can dictate exactly how offer acceptance and when a contract comes into place, okay? So a classic term would be that a lease agreement doesn't come into place until such time as the landlord has signed the written lease agreement in writing, okay? It's a very common clause that's put into contracts. As I say, a lot more commercial contracts, and it basically just means that at the end of the day, the landlord doesn't get bound by this lease until such time as they actually put their signature on. And like in the case that we've got here, it's very common that in those circumstances, a lessee or the tenant will sign your lease agreement first, so that the landlord at the end of the day has the ultimate say and can sign, you know, the lease agreement. And then that might be the mode of acceptance, okay? So then the contract comes into being. But what's important and what we don't have in this particular question is whether acceptance of the lease agreement was communicated effectively to the tenant in the circumstances, okay? That we were told that the tenant has signed the lease agreement that was provided, I'm assuming, by the landlord in the circumstances, but no countersigned lease agreement ever went to the agent or the tenant in the circumstances, okay? So what we don't know is the content of the particular contracts, okay? And we don't know what the communication between the parties in respect of the lease agreement was. Remember, in South African law, a written lease agreement is not required for the formation of a valid lease agreement. You can still have a verbal contract, okay? You can still have, you know, one party signed and the other party says, listen, I can't sign it right now, but I accept that particular lease agreement, and that can still be a valid contract. But what it seems to me in this particular question is the tenants have signed their lease, they've sent it on to the agent, and it's gone on to the landlord. And the landlord hasn't actually gone and communicated their acceptance by the tenant in the circumstances, okay, or of the tenant's, you know, compliance with the lease agreement. If that acceptance hasn't been effectively communicated to the tenant in the circumstance, then the tenant may very well be in a position where they will move on, they can move on and not be bound by the terms of the contract. And that's very, you know, that's very practical. If you think about it in normal contractual terms, if you sign a contract and you want something to happen, and the party who you are contracting with basically doesn't let you know whether they're accepting your contract to try and basically see, I don't know, whether they can find another contracting party, you know, find another tenant at a higher rental or whatever the case is. It can't be expected from you to just sit there unless there's perhaps a term in the lease agreement which says that your offer is irrevocable for a certain period of time. This is also a very common clause within written lease agreements. So you can't revoke your offer for whatever period. Okay. If there's no such clause, no clause that specifically defines that period, you can't just wait forever and wait on the landlord to come back to you at any point that they deem appropriate. Okay, so there's really a bigger question here for me on the acceptance by the landlord. Was it required to be in writing and communicated to the tenant? And we know that didn't happen. And if it wasn't, was there any other form of acceptance that was communicated by the landlord in the circumstances to the tenant to make the tenants aware that the agreement of lease was now in place between the parties? If that is lacking, I think the tenants might be in a position that they are not liable and not bound by the terms of the lease agreement. On the other hand, if there was a firm communication, whatever the means was, to the tenant to say, look, I'll get the lease back to you, but I accept it and the lease is in place at this point, then the tenant is going to be bound in the circumstances. So unfortunately, the question is lovely. There are some additional details that would be needed depending on the facts of the particular case, that would actually determine the exact answer to this particular question. But that's a high level, just what happened in the circumstances.
Agreed. Yeah. So thank you there, Nick. And thank you for the question from one of the agents. I hope that also sufficiently answers your question. And if not, you guys are always welcome to just pose up any follow-up questions in the comments. And if it's a short answer that we can provide, we'll simply just post a comment and then I'll answer it there. If not, then we'll do another short video insert for you guys. But besides from that, that does bring us to the end of our episodes today. And thank you very much for everyone for joining us. And thank you, gentlemen.
Thanks so much.
Thanks, guys.
Cheers.
Cheers.